Judgment in the matter of Saxon Woods Investments Limited and others against Costa.
This appeal is about the standard of behaviour required of a company director when the director genuinely disagrees with his or her fellow directors as to the best way forward for achieving success for the company and its shareholders. The director may be a man, a woman, or even another company. Since the director in this case is a man, I shall refer to the director as he. Can the director simply act single-handedly in driving the company towards his preferred objective, if necessary, concealing from his colleagues what he is doing? Or should he disclose his opinion to his colleagues, discuss it with them, and assist them in forming a collective view about the best way forward for the company? Most companies provide in their internal rules that the business of the company is to be managed by the board of directors as a whole, and by majority vote if they disagree. The present company is no exception. Company directors owe a fiduciary duty to the company, now summarised in section 1721 of the Companies Act 2006, as follows, quotes, "He must act in the way that he considers, in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole." End of quote. For over 150 years before it was codified in the 2006 Act, this duty had been developed by the common law by analogy with the fiduciary duties of trustees, and was generally known as the duty of loyalty. The question arising on this appeal is whether a director who disagrees with the strategy decided upon by the board and decides to act covertly and single-handedly to cause the company to pursue his preferred but different strategy, as I have described, commits a breach of this duty. The key facts may be shortly stated. Spring Media Investments Limited, which I'll call the company, is the holding company of a group which provides creative services to businesses in the fashion, beauty and luxury brand sectors. Mr. Francesco Costa was, at the material time, a director of the company and chairman of the board of directors. He was also the indirect beneficial owner of a substantial block of shares in the company. Saxon Woods Investments Limited was a 22.33% shareholder in the company. In May 2016, the company's board decided to pursue a business strategy, which I'll call the exit strategy, designed to lead to a profitable disposal of its business or of its shares by not later than the end of 2019. That strategy was approved in an agreement between the company and its shareholders, which I will call the shareholders' agreement. The company was committed to that exit strategy and to the shareholders' agreement by its board, which then entrusted the implementation of the exit strategy exclusively to Mr. Costa. But Mr. Costa thought he knew better. In his view, 2019 was too soon for the company to achieve the optimum value for its business. He set about arranging for the company to achieve a sale at a significantly later date, in or after 2020, and he concealed what he was doing from all but one of his fellow directors. This involved misleading them into thinking that he was pursuing an exit for the company by the agreed deadline of the end of 2019, and preventing them from any involvement with the exit process, which might have revealed to them what he was doing. His attitude towards his fellow directors, as described by the trial judge, was, and I'm quoting, "They wouldn't like it now if they knew, but they will thank me for it in the long run." End of quotes. Mr. Costa succeeded in delaying the sale of the business until well into 2020. Unfortunately for him, for the company, and for all its shareholders, the unexpected arrival of the pandemic destroyed all prospects of a profitable sale. Saxon Woods brought proceedings as a minority shareholder against Mr. Costa, alleging that he had caused the company to depart from the agreed 2019 exit strategy and thereby caused the company to act unfairly, prejudicially towards it as a shareholder, not least because of the breach of the shareholders' agreement committed by delaying the exit beyond 2019. Saxon Woods alleged that Mr. Costa had acted in breach of his fiduciary duty under Section 1721 of the 2006 Act. The relief sought was that Mr. Costa should buy out Saxon Woods shares at the price they would have fetched in 2019. The trial judge found that Mr. Costa had indeed caused the company to act unfairly prejudicially towards Saxon Woods, but that he had not acted in breach of his Section 172 duty. This was because he had genuinely believed that it was in the best interests of the company to delay the sale beyond 2019. The judge ordered Mr. Costa to buy Saxon Woods shares in the company, but only on condition that it be proved at a further hearing that if an exit strategy had been followed, the final offer of more than $75 million would have been received by the end of 2019. The Court of Appeal decided on the judge's findings of fact that Mr. Costa had acted in breach of his Section 172 duty, mainly because his conduct towards his fellow directors in concealing from them what he was doing had been dishonest. They ordered an unconditional buyout. Mr. Costa appealed to this court. His principal ground of appeal is that if a director acts in the genuine belief that he is promoting the success of the company, then he cannot be guilty of a breach of the Section 172 duty, and that it would be wrong to import into Section 172 the modern objective test for dishonesty. We have decided unanimously that his appeal should be dismissed. I give the only judgment with which Lord Sales, Lord Hamblin, Lord Burrows and Lady Rose all agree. Our reasons are in summary as follows. 1. It is true that Section 172 enshrines a very long-standing rule that the court will not second-guess the business judgment of directors as to the best way forward for their company. This applies both to the decisions of the board as a whole and to the business judgment of an individual director. To that extent, the test of breach of duty under Section 172 is indeed subjective. 2. But no case has established that just because an individual director forms a genuine belief that the success of the company would be promoted by adopting a business strategy different from that decided upon by the board, he thereby has carte blanche to pursue that different strategy behind his fellow directors' backs. 3. Section 172 requires a director to act in good faith, and the duty which it enshrines is still properly described as a duty of loyalty. Good faith is not just a requirement of the director's thinking about what would promote the company's success. It is a requirement of how he then acts. 4. The alternative view that the requirement for good faith merely governs the director's thinking rather than his conduct, although having an initial purely grammatical attraction, is contrary to the thrust of the pre-existing law about the duty codified by Section 172. It would fail to fit in with the context and purpose of Section 172, and it is difficult to believe that it can have been intended. 5. Although the Section 172 duty is owed to the company, both good faith and loyalty are to be regarded as requirements of the director's conduct towards his fellow directors, since they in effect represent the company for this purpose. 6. It is no answer to a claim of a breach of the Section 172 duty that where a director acts otherwise than loyally and in good faith, he may also be committing a breach of one or more of the other general duties now set out in the 2006 Act. In the present case, Mr. Costa was probably in breach of the general duty to act in accordance with the constitution of the company, and of the general duty to exercise his powers for proper purposes. But his conduct in concealing his implementation of his preferred strategy was plainly not in good faith and was obviously disloyal. 7. For these purposes, the test of good faith is not entirely the same as the modern objective test for dishonesty, upon which the Court of Appeal primarily relied in finding that Mr. Costa had acted in breach of his Section 172 duty. 8. The Court prefers to express no view upon the Court of Appeal's alternative holding that in causing the company to act in breach of the shareholders' agreement, this was itself a breach of Section 172 because the shareholders' agreement conclusively established the strategy for the promotion of the success of the company. There are circumstances where it will not be a breach of the Section 172 duty, for directors to cause the company to commit a breach of contract. Nonetheless, since this court concurs for slightly different reasons with the finding of the Court of Appeal that Mr. Costa had acted in breach of his Section 172 duty by his conduct, the unconditional buyout order which the Court of Appeal made should be affirmed. The court is now adjourned.